Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hope you guys are having an amazing day. So, this is a DJ Akademiks update. So, there has been some updates on his New Jersey cases. As you all are aware, he has a total of 3 civil cases that are active: an SA case out of New York, an SA case out of New Jersey, and a dog bite case out of New Jersey. The last that I spoke with you guys in regards to this, there hasn't been any movement as far as the New York SA case, only because at this time the appellant and the appellee has submitted their briefs as required by the court, and they have submitted that to the court for the judge to review. So pretty much what happened in that case is that that individual who filed suit against DJ Akademiks, she actually ended up filing suit. He was served, but he failed to respond. So when you don't respond to a lawsuit, but you have been served, you can enter in a default judgment. A default judgment was entered and a default judgment was granted. DJ Akademiks then files an answer after the fact. In addition to filing that answer, he requested that that default judgment be vacated and to allow him to proceed with the court case. Right? The judge said, well, for her, he was like, because she even filed an opposition to go against vacating that default judgment. But the judge told her no and told DJ Akademiks yes. So she wasn't having it and she appealed it. So right now they are in appeals court, and she's trying to let the appeal court know that the trial court failed to even consider her opposition to vacate or get rid of the default judgment, because that's not fair. He didn't answer in time, right? So that's what they're fighting. So as of right now, the appellate court has to review the decision of the lower court to determine if they ruled in error. So we're waiting on that. Hopping over to New Jersey. Let's get it to that. So last we spoke, Tyrone Blackburn, who is representing the plaintiff, filed a motion to compel discovery on July 18, 2024. He said either uh, compel them to provide me with what I requested, or in the alternative, remove the answer from a default judgment. That was done on December 18th. Now we are at January 2nd, and DJ Akademik's attorney said, hey, listen, I went ahead and I submitted all the discovery responses as requested to Tyrone Blackburn, and I even put on a drive, a USB drive, surveillance footage, video, and audio, and I overnighted it to him. So I complied. All right. So since he did that and he put that on record, the judge had to come back and he had to rule on that motion, because you never want an active motion on the docket. So the judge went ahead and he ruled on it, because remember, this is what Tyrone Blackburn was asking for, because the defense attorney, DJ Akademik's attorney, wasn't doing what he was supposed to do. Tyrone Blackburn asked for them to comply with providing discovery, to be sanctioned because they weren't turning over discovery, to pay for the attorney fees and costs, as well as set this particular motion before the court so we can talk about it. But since DJ Akademik's attorney complied, with providing the responses and the surveillance and whatever other documentation or production he requested, um, everything is all good. So the judge pretty much denied Tyrone Blackburn's motion only because discovery has been sent over to him. So now the next process is to review all of the discovery, go through all of the if there's footage, if there's audio, if there's social media, whatever they have to go through all of that information, determine if they have to hire experts or whatnot to go through that. um, and not just Tyrone Blackburn, but also if Tyrone, the plaintiff's attorney, if they were sent requests as far as information to answer, questions to answer, or a request for certain documents or production to be sent over, they would also have to send it over to DJ Akademiks to review. That's a whole part of the discovery process. The next part would be depositions. So this will be where Tyrone Blackburn will depose uh, um, DJ Akademiks and whoever else is associated with them or him. And DJ Akademik's attorney will actually depose Miss Abashi, who is the plaintiff in this case. Once they do that, a lot of people, man, depositions is where you find out a lot of information. So they'll take the information that was, given in these depositions, along with the information that they got from the interrogatories and the request for production, and they will then determine if any other records are needed, if any experts are needed. And once they do all of this, then they move on to mediation. And then at mediation, that will be an opportunity for the parties to be mediated and come to some type of settlement agreement. If that doesn't work, then they go to trial. But this is the time where they have to kind of really go through these documents and whatever else was produced. I am assuming like surveillance, because it's known to everybody he is a YouTuber. And so I'm pretty sure you have cameras everywhere. And from what has been floating around on the internet, I'm pretty sure that they're going to get their hands on that footage, and they're going to have to hire some experts and forensic analysts to kind of go through those videos and see the authenticity or validity of those the footage, and see if it has any correlation to what happened to this assault case. It's very, very different because it is a SA case. It's not like your regular dog bite case or other personal injury case. This is a SA case. So the information that is requested from the other party is very vital in the plaintiff's position, because that is what they use in order to corroborate their story. It's not like she's going to have surveillance or anything of that nature to, say, okay, this has happened. Here you go. All right. We know DJ Akademiks has cameras around his house. We know that he's actively on, social media, especially his Twitch and YouTube. So it's going to be a lot of things that happen. As you can see on here, their discovery ends on 11/28/2025. So they do have a longer period for discovery. But the only thing I can do is just keep a watch out and see if anything, arise out of this case. Nothing really is going to be viewable to the public or to me, even looking at these court dockets, only because it's during discovery. Now, if they choose to put out, a clip or a transcript, then that's the only way we're gonna, know what happened at that time. But until then, we won't know unless the case has been settled at mediation or if it's heading to trial. All right. So that is on the New Jersey SA case. The next case is the dog bite case that a lot of people are not talking about. It's crazy because it's just like, you let your dog bite somebody and you're not taking accountability for that. So this complaint was filed back in January, a whole year, well, almost a year ago. She was having difficulty trying to serve this man. So Complaint was filed January 24th of 2024. They tried to serve him, but weren't able to. So what they did is they actually ended up they filed an amended complaint, and I think it had to do with the address. I think she probably had the wrong address. I'm not sure. But they ended up having to file a motion to substitute service because they could not serve him in person. So they ended up filing a motion to substitute, and it was actually granted. And that allowed them to tape a copy of the summons and the the lawsuit on the door. Now, he did not respond because, mind you, I believe in New Jersey you either have 20 or 30 days. So either way, I believe he was served on the 4th of June, which means July 3rd or July 5th, because July 4th was a holiday. He would have had to respond. He didn't respond. So on July 12th, as you can see, she entered in a request for default because he didn't respond. The default was entered on July 15th, right? And it was granted. Now, all of a sudden, your boy ended up hiring a lawyer, and that lawyer submitted a motion to vacate the default judgment to allow him to continue litigating this case. And the judge granted that. So, in other words, she overturned the default judgment. Once they did that, then he went ahead and he filed his answer and then also a counterclaim. And if you don't know what that counterclaim said or read, go back and watch the video. It is in the DJ Akademiks playlist. And that's the last that we heard of that. So he filed the answer with the counterclaim. Here comes a couple of days ago on the 7th, the attorney for the plaintiff files a motion. And that's what we're about to hop on into. So let me go ahead and download that. All right. So here is a motion to suppress defendant Livingston Allen's answer for failing to answer discovery. So once again, let's see. He filed his answer on July 26th. Once you file your answer, that is when discovery starts. And y'all been with me long enough to know what discovery is, so I don't have to explain it. So obviously, plaintiff's attorney submitted discovery request to DJ Akademiks, and I don't know if DJ Akademiks attorney submitted, discovery to the plaintiff, but we know that discovery was sent over to DJ Akademiks, and he has failed to provide any of that. So what the plaintiff's attorney is asking is, can you please strike his answer off of the docket because he failed to answer discovery? So let's see. So it says, please take notice that the undersigned shall make application to the above named court on Friday, January 31st, 2025. So they have a hearing on this on January 31st. I'll definitely be back with the update. Therefore, as counsel may be heard for an order suppressing defendant Livingston Allen's answer for failure to answer discovery. Why doesn't this man what is it with him? And I'm starting to think that maybe he's trying to, how do I want to say it? Like trying to do something with discovery, like the evidence. I don't know. That's just my theory. Don't quote me on that. Anyways, it says the undersigned shall reply upon the certifications annexed here too. Okay, so proposed order. So they waive oral argument and consents to the deposition on the papers, meaning that they don't want this to go before the judge. They don't want a hearing. They just want the judge to review the documents that they're submitting and make a decision off of that. So let's see what they submitted. All right, so certification of counsel, and this is of the plaintiff's counsel, Miss Christina Nicely's counsel. Da, 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 da. All right. This matter stems from a dog bite incident which occurred on November 5th, 2023, at the premises owned, operated, and maintained by defendants Livingston Allen, DJ Akademiks LLC, and Tivoli Gardens LLC. As part of the discovery in the above matter on July 26, 2024, I propounded form interrogatories, supplemental interrogatories, and a request for production of documents on the defendant Livingston Allen. The due date, the discovery was due within 35 days on or before September 26, 2024. On September 30th, 2024, I forwarded a letter to defendant Livingston Allen's counsel indicating that discovery responses were overdue and that if I did not receive same within 10 days, I would be forced to file a motion. As of the filing of this motion, plaintiff have not yet received this defendant's discovery responses. As pursuant to Rule 423-5A, plaintiff is not in default of providing any discovery to the defendant. So that means either they have provided all of their discovery responses and objections to defense counsel, or defense counsel just never really requested anything from plaintiff. So that can go both ways. Therefore, plaintiff Christina Nicely respectfully requests that defendant Livingston Allen's answer be suppressed for failure to answer discovery pursuant to Rule 423-5A1. And it's just saying that he certifies that da 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 da. All right, so let's see. Proof of service. He served them January 6, 2025. Oh, that's them. All right, so let's see. All right, so they asked for interrogatories, supplemental interrogatories, and enclosed notice to produce. Let's see what he asked for. Ooh, child. Provide the name and address of the owner of the dog, which was at premises located at 24 Shallowbrook Road, Morganville, New Jersey, on November 5th, 2023. With respect to the dog, which was at the premises, the dog's age, date of purchase, name and address of purchaser, name of the address or seller. With respect to the dog, provide copies of all licensing and registration documents. With respect to your dog, provide the name, address of all veterinarians that saw the dog within the last 10 years and provide all certificates or shots. For all training given to the dog, which was at the premises, give the name and address of the trainer, describe the training administered, provide copies of all documents related to the training. Um, let's see, for all instances in which the dog was at the premises, is alleged to have caused injury to the persons or property, provide the date of each incident, identify each person or entity making a claim for injury to a person or property, provide a detailed description of each incident. If a claim has been made to an insurance company, identify the insurance policy and claim number. Example, if a lawsuit has been filed, provide the docket number. Identify each and every address at which the dog was at premises located. Is known to have kept. If you have ever required medical attention due to the activities of the dog, which was at the premises on November 3rd, 2023, identify the date of all such incidents. Identify all injuries you sustained. Identify each and every medical provider you saw for said injuries. Provide an executed HIPAA authorization for each medical provider you identify. If plaintiff Christina Nicely was not invited onto your premises on November 3rd, 2023, identify each and every person who advised her that she was not welcome at the premises and provide a summary of each conversation. And then provide the username for each and every social media account you use, including but not limited to Instagram, Facebook, LinkedIn, and Twitter. They should have asked for the YouTube stuff. Mm. So that was the interrogatories. So as far as the production that they requested, any expert reports, hospital doctor reports, office records, medical reports, um photographs, videotape, movies, reproductions, of any of the alleged injuries, damages, or losses that were referred in the complaint. Let me see. Copies of any and all documents of any kind or description which you will rely to the allegations of negligence, liability insurance policies. That's normal. All of this is just standard. Names and addresses of witnesses, documents containing any file maintained by the defendant. Yeah, nothing really that stands out. This is just normal documents that they're requesting in regards to uh the nature of the case. And this must be the supplemental. Oh no, this is just saying, hey, you need to give us our stuff that we asked for. So yep, they've been communicating. They've been communicating, and I don't know. I don't know what type. I don't know if DJ Akademiks is not paying the attorney, and the attorney said I ain't doing no work until I get paid, or what. But this is very crazy. But you seen it in this case, and you seen it in the New Jersey essay case. Like they have to compel. They have to ask the court to make them give the requested documents to plaintiff's attorney. That's crazy. So this case is not going before, not, let me take this back. This motion is not going before the judge. The judge is just going to review everything that was submitted in the motion, and they will make their decision on the 31st whether or not to strike the answer. Because if they strike the answer from the docket, then that will give the plaintiff's attorney the opportunity to enter a default judgment. Yep, and that's that. Hoo-wee. I know some of you be trying to figure out what's going on DJ Akademik's case, and that is where we are at right now. So for the New Jersey SA case, right now, they are currently in discovery. DJ Akademik's attorney finally sent over the requested information that Tyrone Blackburn asked for. And the next thing will be depositions for this dog bite case. The attorney, and it's a different law firm that's handling this dog bite case, not Tyrone Blackburn. But this law office is asking the court to strike the answer so they can enter in a default judgment, since he does not want to provide discovery in this dog bite case. As far as the New York case, the appellate judge is currently looking at the briefs that was submitted by the plaintiff as well as DJ Akademiks. So once there is an update, I will definitely tune you guys in with another video. Thank you guys for watching. Don't forget to like, share, and subscribe. Until then, you all be blessed, and I'm out. Bye.